right here. Changing my title. I forgot to got a Wi-Fi in here. I actually can go live. We're live right now.
Hey guys, joining me. This is a repeat. I'm going to let this play and then I'm going to do some info.
Flood those phone calls for Judge Andre Rudolph. I just say unlisted. It's not unlisted. There we go. I'm still trying to find the screen, I guess. This is beginning to piss me off.
So, for those of you who are just coming on, you're going to listen to Eric here rant very loudly for a few minutes.
Nobody in here after 2 minutes. Something's wrong.
Eric has already disconnected his live stream, so you can watch a repeat of it there, or you can watch it here.
Oh, that's even better.
No, but because he didn't say that.
Because he didn't say that.
He doesn't care about that. That's what he said.
If he doesn't care about that, then you release that goddamn son of a bitch! You goddamn fucking worthless fuck! That's kind of how I feel. I know. Hey guys, I see people are finally popping in here. We got an order from Judge Rudolph. This guy is even more fucking retarded than we thought he was. You fill that fucking courtroom. You bring pennies. You throw pennies at that fucking son of a bitch.
Dang, I didn't realize you said all that.
Until he's buried. That son of a bitch requires a goddamn $100 bond for a homeless man with 2 children. They don't even put this kind of bonds on real crimes. What the fuck is wrong with you people? Call Judge Rudolph. Do not let that phone stop ringing. Do show up in that courtroom tomorrow. This fucking retarded judge, in his order granting a state execution, actually tried to fix the record. You don't get to do that, you lying son of a bitch. You're not more than a son of a bitch. And I'm gonna get you off of that bitch. If I have to take your hair and drag you off of that bitch, you're gone, son of a bitch. You're gone. Your 12-year reign of terror is over. You done fucked with the wrong bitch today. Do you know how I really feel? $100 bond. $100 bond. Cash only bond. On a homeless man with 2 fucking kids. 30 days. 30 days contempt. And we're printing the order here because that retarded fucking schmuck also ran wannabe, never been more than a barely mediocre fucking judicial officer, was a completely worthless public defender. He was, wasn't he? You can't say. If you're not infuriated by this, if your blood pressure's not pumping like mine is, you're not a real person. Get that phone number for Judge Rudolph posted in there now. His clerk is there right now. She's there right now. Because we just got off the phone with her. Let's get that number posted. Let's get the number for that presiding judge posted. Get the fucking number for the governor posted. $100 fucking. As soon as we get that order printed here, I'm gonna read it to you. You're gonna be so fucking mad. Might be able to pull it up here on my phone. Let me see. That goddamn fucking prick thinks he's preserving the judiciary. You preserve the judiciary. I don't have it yet. Did you send it? I don't have it. Would you just print it? Yeah. Oh yeah, of course. Actually, you do. I cannot believe.
Eric
when you read
is
this,
angry.
God,
He's going to be.
so
You're going to be infuriated too, folks, and you need to be. The reason I'm replaying this video is I'm asking each of you to
the original video that I posted
to do some work for us today and tomorrow.
Let's get that posted. People need to listen
Thank you.
to that.
Constituent Services.
When you read this,
Hey, Stephanie London.
and you listen to that, There's no way.
I want you to find for me.
We should not fill that courtroom tomorrow. There is no bid.
I'm going to pause that for a second. I need to say that if anybody is here watching this, sharing this, we really want to reach people in the Denver metro area who can physically come to court tomorrow. And as you listen to this, if you're in feeds on Facebook, Twitter, whatever, we want not only these calls coming in, it's getting close to the end of the day, so we can't necessarily call the clerk's office today. But there's another governing body that I'm going to have all of you call when you hear how fucked up this judge is.
Business. It's this business. Wait till you read this.
I got the discovery. When do we have court? The 19th. Jeez.
All those pages?
Yeah, we better meet them.
8 o'clock, 8:30. We're going to 8 o'clock in the courthouse outside beforehand.
This is going to be tough. Oh, they're offering it the 3rd, by the way.
Wait till you see this. This is ridiculous. This is the order. This is the fucking order. First of all, let me tell you how much work he put into this. This dumb fucker puts all this work in. Ready? Ready? Oh, you guys are mad. Here we are. Gable versus Winston Knowles. Ready for this? 1, 2, 3, 4, 5, 6, 7, 8, 9 motherfucking pages. What the fuck is wrong with you, Judge Rudolph? What the fuck is wrong with you?
I need
It's the pain of 10,000 pennies went through your fucking skull.
lawyers'
Not good enough.
complaints for the state of Colorado. It's municipal judges and lawyers.
The court absolutely did not understand a fucking word of what he said. And you still don't understand because you're a mediocre bullshit judge. Let's see, he says he's sorry for the behavior.
Of course, never ask permission to share videos.
So why is he trying to make a record here?
Is it Eric's video?
just
Share Eric's
for
video.
granting
Share
a
the
stay of
fuck out of it.
execution or not. This is not your fucking opportunity, you worthless fuck, to fix the fucking record. You can't fix the record. You already broke it. Decided to flip off the court. No, he didn't say flip off the court. He said flip me off. He didn't flip off the court. He flipped off you, you fucking worthless fuck.
That's it. The Office of Attorney Regulation.
This was a
That's the
warning
one.
to the defendant about disrespectful behavior. No, it was not a warning to the defendant about disrespectful behavior. It was a warning not to walk in front of the court again. And nothing more. Nothing more, Judge Rudolph. Just strictly do not walk in front of me again. You don't get to make that fit everything else. Your order for contempt is wrong. And you're gonna get a spanking. We're coming for you, Rudolph. You are done. 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 Get off our fucking bench.
Ladies and gentlemen, the Office of Attorney Regulation needs your phone calls. You need to call Rosemary, and Rosemary does phone interviews for the Office of Attorney Regulation. She, her number, as Stephanie has put it up there, 303-457-8500. Rosemary refuses to schedule an appointment with me in person because I don't like doing phones. It causes me stress sometimes, especially when I'm trying to communicate. And we have anger inside of us like this here, which you see from Eric, folks. Yes, it is a bar complaint. And here's the deal. The municipal judges are ruled and organized by this association, the bar, they are not. They're very special in Denver. They don't get the same judge scrutiny. So so district judges, state judges have a different level of scrutiny. It's different than that of lawyers, and the office that handles lawyers also handles the municipal judges for the city and county of Denver. Why are you calling? Listen. No, not the Colorado Commission on Judicial Discipline. That is not it, Stephanie.
You bet you don't know anything about why he came back into the courtroom. Court describing it, what it witnessed. Inappropriate. No, he didn't know it was inappropriate, and I still think it's appropriate. I think if you were drawn and quartered, Rudolph, it would still be appropriate. That's what I think. And there's nothing you can do about those thoughts. $100 fucking dollars.
Stephanie.
Are you fucking kidding me? The legal analysis regarding contempt. You're gonna get your fucking legal analysis regarding contempt. Because you didn't meet it, you still don't meet it, and you're still being abusive. Contempt this, you fucking bitch. Fuck you, Judge Rudolph. We're all gonna come for you. Get off that bench now before we embarrass you and your family any further. He didn't say dignity of the court. He said you flipped me off, and I'm not gonna tolerate it. I will show you respect, and you will respect me back. That's what he said. That's what he said. There's no fucking respect for you, Rudolph. None. You should have posted the rules and read the rules of contempt before you fucked it up. So all this tries to fix the record.
He's gonna have to do one or the other. We're gonna bond him out.
Must be used with caution and self-restraint to vindicate the rights of litigants and promote the administration of justice. This is an outrageous abuse of discretion, and you made it even worse. You vindictive, vile, petty, worthless, goddamn childish son of a bitch! The court did not find the defendant in contempt for its disrespectful behavior as he left the courtroom. The court, prior to the contempt, explained to the defendant why other exhibited behavior was just no. That's right, what other exhibited behavior. You can't fix the record. You can't make it fit after the fact. You're unfit to be a judge, Rudolph. Get off the fucking bench! The defendant displayed the very behavior the court was addressing in the first instance. No, he did not. The first behavior was walking in front of the court in the well. It's a totally different behavior. And it's a restriction. You worthless fuck. There's nothing worth. You would not even be worth melting you down for your medals. That's how worthless you are, Rudolph. Even if you have gold teeth, you're not worth it. There are cockroaches suffering for lack of water and oxygen because of you. The defendant did apologize, in fact. It did make him feel good as an American because we have the right to free speech, unless you get spanked by a fucking judge that's got his panties in a twist. See, he goes on and on and on as a response to the contempt motion. This isn't a response, it's a mandatory fucking state of execution, you worthless fuck, and that son of a bitch will serve every fucking 30 days in jail. I hope you die a painful 3-year death of bone cancer. Bone cancer, Rudolph, that's what you deserve. Bone cancer, the most painful way to die. Pending the docket of execution of appeal, a stay of execution shall be granted. Mandatory. The defendant may be required to post bail. May Reasonable bail, Rudolph. Reasonable bail. $100 fucking. That man stood there and told you that he was homeless with 2 children. He got a parking ticket because his vehicle was left behind. The man doesn't have any fucking money. You read his application. He has no fucking income. $100? They don't even impose that on defendants with real crimes in Denver. What the fuck is wrong with you?
I'm living right now. So that, folks, was Eric's video. He just did, and I want to pull up a couple of things here. The first is the Chief Justice Directive 0404. And Eric's at the lawyer. So what if Eric gets angry about what? The fact that Otto's in jail? Yeah, obviously. The judge is sickening, and really nobody gives a fuck if who shares Eric's videos and reposts them. I'm doing that because I can't yell like Eric. Eric has that with himself. But we want you to know that you can call the courts. And I need to cut a couple things off my screen here just so that I can show you what we want, what we're looking for. Filing complaints is a verbal phone call for most of you, an audio call, I should say. That would be the Attorney Regulation Counsel. That's right, Stephanie, and I really appreciate that. The Office of Attorney Regulation and Counsel. So let's look at this. Colorado Supreme Court. There we go. They are the office that investigates and prosecutes allegations of violations of the rules of professional conduct by attorneys in Colorado. The Office of the Presiding Disciplinary Judge presides over formal complaints against attorneys. So this falls under magistrates, Colorado magistrates, right? So this is the number to file a complaint, 303-457-5800 or toll free 877-888-1370. And again, ladies and gentlemen, you're going to want to talk to Rosemary. Rosemary does phone complaints only, and she does not do in-person complaints. So drug tests with the bar, I don't know. I don't know. Let's just keep reading through this, this website. I've been to their physical offices 3 different times trying to schedule an appointment in person to file my complaint and to present audio files. The audio files that we have are specific to Rudolph and not exclusive to Otto. We are also remembering that there should be complaints not just about this incident, but about the overall use of the lack of discretion by judges to oversee Chief Justice Directive 0404. 0404, Colorado State Supreme Court, search by number 0404. And we are going to get the instructions for assigning a public defender. No, oh, wait, what? Complaints against attorneys. So, the Office of Regulatory is authorized to investigate magistrates, attorneys serving as municipal court judges. You see, these guys also handle that they have to be municipal court judges and magistrates. Okay? So Colorado magistrates, attorneys serving as municipal court judges, authorized to practice. Yeah. So the reality is that this is the office. Okay. If you want to have concerns about what they're violating, we can go to the Colorado Bar Association and see that that page isn't there. Isn't that wonderful when that happens? Issues may not be ethical misconduct. The office. Oh, here's what is not. So let's just read it. The Supreme Court has established rules of professional conduct for attorneys. The rules are contained in appendix to chapters 18 to 20 of the Rules of Civil Procedure. The procedural rules for the investigation and prosecution of alleged violations of the rules of professional conduct are located in chapter 20, Rules of Civil Procedure. The Attorney Regulation Council is committed to treating all participants in the process with dignity and respect, even though Rudolph doesn't deserve our fucking respect. The resolve a matter that is fair to the complainant and to the attorney. An attorney who violates the law or the rules is subject to discipline. This is very clear, right? So the judge can be disbarred. In cases involving minor misconduct, they may be admonished, censured, or placed in a diversion program. Rudolph's already in a diversion program. He may face suspension of their license to practice law or disbarment. That at this point is probably the best answer for Rudolph. Retire or get disbarred. This group receives many requests for investigations about conduct that do not violate the rules of professional conduct. For example, honest disagreements with their clients on how a case is filed or should have been handled have not engaged in professional misconduct. An error in judgment does not necessarily violate the rules. However, we need to find what is a rules for professional conduct. And since that's not appearing over and over again, we'll do it in a different way. And that is to find Chapter 20 of the Colorado Rules of Procedure. Because the courts... NorCal, that's great. Here's the reason. Yes, but it's, again, everybody, you have to understand that I've been through this for 2 weeks. Selena, I appreciate it, but this is the right organization. The Rules of Civil Procedure, compliance. So, in the event that a registered attorney or judge shall fail to complete the required units, I'm sorry, I'm just going to skim through this a little bit because I can read faster than I can talk. Okay, that doesn't really do me much. Hi, everyone. So, yes, we know that it's not the judges. I've been, and the reason I know that is because I've been to their building. I've gotten passes, past security to go talk to people. I've been to see Rosemary 3 different times, and Rosemary refused to have an appointment with me face to face. So, sorry, I know you guys all lost me there. I want to go to verify the number for you all because there's such confusion here. People are asking, so we'll verify. Because I have it saved in my phone. So currently the phone number. Oh, I'm on Signal. That's problematic. Sorry, we're gonna bounce for just a second and come right back to you. And the reason is that I'm trying to split screen so I can check the phone number on my phone to ensure. And since I called them today, and she refused to take that call, I know that I have it in my phone. The Attorney Municipal Complaints is 303-457-5800. And if that doesn't work, you can call. Again, if that doesn't work, you can call 5801. And you can ask for Rosemary. And obviously, the complaints are in appendix to chapters 18 to 20. So we'll just Google that and see what shows up there. Because we want to see the civil procedure. What's the complaint? The complaint clearly is that the Chief Justice is violating 0404, which is what I was trying to pull up for us earlier. And the complaint, who pissed you off? Well, your family pissed you off. Well, rumor has it, we're a Mecca. So it must be underneath here, huh? Let's find that again. Search by number 0404. Oh, I know why. There's supposed to be a dash in there. See, sometimes these, advisory council appointments. Why are advisory council appointments necessarily important? That's not the right way to look at it. There we go. The policy is adopted to an administration of justice with the respect of counsel for criminal cases. Federal and state constitutions provide that an accused person has the right to be represented by counsel in criminal prosecutions. You all have to remember that Otto was in court the first time for a criminal prosecution. That's how he ended up in front of the judge to be in contempt of them. So you have to remember that Otto said to Rudolph, I'm homeless. I have kids living with me. I can't afford to pay for my own attorney. And state funds are appropriated for all these purposes. Provide for the appointment of a counsel for an indigent person cited for contempt where a jail sentence is contemplated. That's why Otto has a counsel now. Here's the indigency. And this is what we want to make sure you all understand. All parties requesting court-appointed counsel pursuant to this Chief Justice directive must be indigent to be represented at state expense, except as otherwise provided in Section 3. Such persons must also be indigent or qualify for counsel in these other section for the court to allow payment for costs and expenses. Must complete Form JDF 208, application for public defender, court-appointed counsel, or guardian ad litem, signed under oath. An indigent person is one whose financial circumstance prevent that person from having equal access to the legal process. What is equal access to the legal process? Equal access says that if you have, thank you, Eric Brandt, if you have a need to be represented by law and you cannot afford an attorney, one will be provided to you. How poor do you have to be before you cannot qualify for affording an attorney? Let's find out. Oh, and before I get too far, the initial determination of indigency in criminal cases shall be made by the public defender, subject to review by the court. Key, subject to review by the court. I don't know if Eric's played this audio file for you before, where the judge, Rudolph, has specifically said, I don't want to review this. The public defender knows how to do their job, and I shouldn't be double checking them. So therefore, the public defender's decision is subject to review by the court. Therefore, all persons seeking court-appointed representation shall complete the form JDF 208 and shall first apply with the public defender. The party must complete the form and submit it to the court for approval. Well, if the public defender doesn't take the application, how would the judge have it? Remember, the public defender's office refused his application. The public defender's office refused Otto's application because he did not show his lack of income on paper. He didn't have somebody write a letter saying that they know Otto's poor and that he's homeless and that he lives in a vehicle or whatever, right? You can't prove a negative. That's correct, Selena. And so it's an oath. It's an oath. Your word is your bond. It's that simple. It doesn't have to be any more complicated than that. If you're caught lying to the courts, you go to jail. I can live with that. You should live with that. Don't lie to the judge. And as a matter of fact, Otto didn't lie to the judge. But what we find out is that the judge is lying and trying to cover his assets. Let us continue. In all cases, the court, not the public defender's office, the court retains jurisdiction to determine whether the person is indigent based on the information available. When you stand in the courtroom, and remember, this is not an empty courtroom. This is a courtroom full of people who are there to answer for their alleged crimes to the state or against victimless persons, whatever you want to call it. Most people who are in court are not there for good cause. The cause is the zealous police departments that prosecute people for trying to survive and trying to live. In all cases, the court retains jurisdiction to determine whether the person is indigent based on all the information available. If a man walks into a room and says, I'm poor, I'm homeless, I live in a car with my children, that's all the information available under oath. Do you get it, people? This is not a game that we're playing. Who would want to go in front of a court and give that information and lie? Who would feel good? Who in their right mind would do that? Nobody. Nobody would do that. So in all cases, the court retains jurisdiction to determine whether the person is indigent based on the information, all the information available. And upon receipt of the finding by the public defender on the issue of eligibility for representation, in accordance with fiscal standards, the court shall review the person's application for public defender, including any request for exception to the determination of the public defender. Based on a review of all information available, the court shall enter an order either granting or denying that person's request for appointment of the public defender. That's what the appeals process is for, is what Rudolph said. You don't like my decision? That's what the appeals process is for. Okay? Well, his decision was not to deny or accept the opportunity for Otto to have a public defender. Therefore, no decision could be appealed. The court may use the judicial district's collections investigator to provide a recommendation to the court relative to the above determinations if an additional analysis is needed. Now, for those of you who are playing along at home, let's go through a series of circumstances. I'm going to do a little research here and see if I can find on YouTube.com Liberty Freak. Choo choo swallow. Liberty Freak TV Court. Let's see what we find. Liberty Freak TV. We've got that. Sorry, I'm trying to do a quick search and view while we're going through all of this. I'm not going to keep it on me. You're going to watch me screw the screen up. So as we look through Liberty Freak TVs, we're going to see if he has a video. Normally I'm out of practice. I would have prepped all this shit up for a while. Sleeping. Dangerous lies told by security. The state granted me defense. The city of Denver still denies it. Liberty Freak TV. If you haven't watched this, we're going to skip the commercial. Also notice the lagging. Oh yeah, let's just skip the commercial, mute the ads, so we don't want to pay anybody else for getting free video on my stuff and my time. Let's just see what Liberty Freak has to say. Get offline, folks, and answer those. Damn, it's up to Scott's Day.
Happy Scott's Day.
Hey, supposedly free. We're going to court tomorrow. 8 a.m. chalking, maybe 7:30. I haven't quite decided yet. What do you guys think? 7:30? 8 o'clock? Sunrise? Sunrise chalking. That's it. Sunrise chalking and protests at the Capitol. We're making an event here shortly. You know... Is he even going to talk? I don't know. Sunrise chalking. Yeah, that's what we're doing. So, Selena, I guess we'll see you tomorrow? Yeah, it is. Sunrise is cold. It's cold what Judge Rudolph continues to do over and over again. And this video that Liberty Freak is sitting here typing away on, if my assumptions are correct, is where he's been approved by a public defender for the state, but Rudolph basically shoots him up to another judge because Liberty Freak had an amazing, honest conversation with Rudolph, and Rudolph actually... Richard Arnold, my Venmo, and Cash App are Cut the Plastic. Oh, Selena, sorry. I thought you were in Denver, or in Colorado Springs for some reason.
What's up, Tucson, Lori?
So, still waiting for Abby to speak here. Tell us what happened in court when Rudolph denied him access.
Where's our license? Okay. See how quickly the intimidation ended?
Wow, what the fuck? Okay, that was a whole waste of 3 minutes. Omaha, J. Lee Doe, come on down. Come on down. Nebraska, I mean, leave it, go to bed now. Get off the channel, go to bed. I don't know, Nebraska's like 5-hour drive. Get up at 3, you'll be here in time. Right? So I remember this. This is absolutely the day I was looking for. Obviously, there's a giant gap of stuff there, so we're screwed on that. We're gonna go back to 0404 because this is what's live stream. You'll get up early. Yeah, well, we're all gonna have to get up early for this. I promise you that. It's a good thing I'm now a salaried employee. I can work when I need to. 5 hours from western Nebraska. I don't remember. I'm calculate it, plan it. Come join us. We'll put some money in your gas tank if you need it. We'll feed you, whatever. This is all about bodies. We're not going to go to jail. Protesting outside the courthouse is not a jailable offense. Chalking outside is not a jailable offense. Everybody walking into that courthouse tomorrow needs to know what the fuck is going on. So, let's cover some more of this. The court may use the judicial district's collection investigator. The reason I went to Otto or to Abbott's feed is because that's what Rudolph said. He said to Liberty, we can go through this and we can use the judicial collections to verify it. We almost had it. And then Abbott decided that he didn't trust Rudolph's integrity and he wanted a different judge, and it was honored. So we didn't get to test the collections division's process of verifying a public defender. An attorney or other person appointed by the court on the basis of the person's inability to pay the cost of appointment shall provide timely notice in the event financial related information is discovered that would reasonably call into question the person's inability to pay such costs. Okay, this is in custody and cannot allowed. Guidelines for the appointment of the public defender. Let's cover this in detail. To be eligible for representation by the public defender, the defendant must be indigent or eligible for automatic representation is defined above, as determined by the PD, subject to review by the court. Over and over and over again, they line this out. Determined by the PD and subject by the review of the court. The court must review it. If a person is indigent or is eligible for automatic representation, i.e. you're in custody, the court shall appoint the PD, except as otherwise provided in paragraph 5B. We're going to get there, 4B. 6B. I'm lost. No, that's 4. Appointments to assist in motions. An indigent defendant may be entitled to representation by the public defender to assist in motions under Rule 35. The court does not deny the motion. Criminal. Charles PD may be appointed. So if you have a lawyer and they withdraw, you can have a public defender. Appointments for appeals. The court or the PD shall reassess the indigency status of a defendant who requests court-appointed counsel. How many times does this have to say it? And remember, folks, this is the instructions of the state Supreme Court. And the reason that we are going through this is because if the instructions of your boss are something that you can't follow, then maybe you shouldn't do a fucking job. If you can't follow a simple task, a simple instruction that your boss gives you, it's time to quit or get fired. So if the public defender denies a person for the public defender, and the courts shall reassess the indigency status for purposes of the appeal. And when an indigent person has an alternate defense counsel attorney for the trial of a criminal case, the PD shall be represented to appoint the defendant on appeal unless there's a conflict of interest. We don't need to worry about alternate defense counsel appointments. Other counselors available. Appointments of counsel for grand jury witnesses. Appointments for counsels of witnesses. Right? Get it? Get it? This is so detailed that if you're poor and you're subpoenaed to appear and testify in a court hearing, you may be appointed to counsel if the witness requests counsel and the judge determines the appointment is necessary to assist the witness in asserting his or her privilege against self-incrimination. Huh, what do you know? Let's carry on. Costs are lined out. I'm getting to something that's very important, and it's the amendments. There's investigators. There's all kinds of important stuff in here for fees to the lawyer who defends somebody who's indigent or proceeding pro se. Okay. Yeah, we're going to keep going. Reimbursement to the state. All written complaints and documentation of verbal complaints regarding performance of any state paid counsel can be taken to the district administrator. Let's see how much farther this goes. Oh, wait, there's attachment A. This is what we're looking for. Find fiscal standards of eligibility scoring instrument. Let's just read this. Gross income from all family members of the household who contribute monetarily to the common support of the household. Income categories include wages, tips, salaries, commissions, payments received as an independent contractor for labor services, bonuses, dividends, severance pay, pensions, retirement benefits, royalties, interest, investment earnings, trust income, annuities, capital gains, Social Security disability, Social Security supplemental income, workman's compensation benefits, unemployment benefits, and alimony. Okay? If you're at or below the guidelines, and this is key, this is very key information. If you're at or below the guidelines, your automatic point score is 150. If you make up to 10% of the guidelines, you're at 100. 11 to 75% above the guidelines, up to 10% above the guidelines. Okay? Not eligible if income is more than 75% above the guidelines. You don't get it. Okay? Expenses versus income. There's a reason that the expenses a person has to be taken against their income. Because if you don't have any income, that's fantastic. You're going to qualify. But if you make more money than the guidelines, we have to know if your expenses versus income matter. So the expenses for non-essential items such as cable television, club memberships, entertainment, dining out, alcohol, cigarettes shall not be included, etc. Right? So your Mountain Dews, your Red Bulls, your chocolate bars, these are non-essential items, right? What's essential? We're going to get to that. Charge, the most severe, the type of charge is also important versus the assets which could be used to pay defense costs. This is big deal because you're allowed to have assets. If you have a misdemeanor, class 1 to class 3 misdemeanor, or a jailable traffic violation, you're still allowed to have some assets, right? You can have $1,500 in the bank to survive next month, have a month's income or savings, and that's not really a month's, but you get the point. Okay. Total points, 150 or greater. Indigent, eligible for the public defender. Less than 50 points, eligible. And then there's an exception requested to allow appointment of the public defender alternate notwithstanding the above score. Documentation justifying the request is attached. So, every time the public defender's self-scoring sheet that's given to them is processed, there's an ability to ask for an exception every time. And then the judge must review it. So let's look at your family size. And your family size based on monthly income is plus 10%, or your annual income plus 10%, right? So this is your yearly income plus 75, where you don't qualify ever, right? But a family of 3 would have to be making $46,660 in order to never qualify for the public defender. $46,000 for a single mom with 2 kids, a husband and wife with 1 child, a single father with 2 children, right? Whatever it is. For family units with more than 8 members, oh my gosh, add per monthly incomes or annuals. And this is a federal register, 1/11/2019. That's this year. Look at this. This is 2019, the most recent formats. These, ladies and gentlemen, are the papers that I pulled out of the courtroom on Monday. I want you to see that number right there on the bottom. What does that say? It says JDF 208. That's perfect. Revision 10 of 2015. Single-sided. This is the document for application to the public defender that sits in Rudolph's courtroom. You're going to learn why this is important if you don't already know shortly. Well, let's just show you. Here's the 2015 version. And there's the backside of it. In Rudolph's courtroom, they don't even have a backside. Page 2 doesn't fucking exist. I'm not done. Fiscal standards procedures for the determination of eligibility for a court-appointed counsel on the basis of indigency. Fiscal standards. This is not a willy-nilly determination, people. This is an intentional fact-finding hunt. A determination of indigency is necessary for certain appointments addressed in Chief Justice Directive 404. Now remember, Chief Justice Directive, the head top judge in the state. Rudolph's his subordinate. So if you can't follow your boss's orders, quit your job. Any defendant in a case or persons involved in matters described under the other areas that we skipped through, requesting court-appointed counsel on the basis of indigency must apply for the counsel as described below. The public defender or court staff will determine the applicant's eligibility for the appointment in and. See this word here? This is a key flipping word. And staff. It's not a singular or. One or the other can do it. This is not willy-nilly processes. The public defender looks at this and then they are reviewed. Their work is examined and verified. It's an and. It must occur. They will determine the application in accordance with the following procedures. In criminal cases, they shall apply for the public defender by completing the application form. If the defendant is in custody and cannot post or is not allowed bail, they are automatically able to elect to represent. And the person's income is or below the income eligibility guidelines, and he or she has no assets. As determined on Form JDF 208, the public defender or other counsel shall be appointed. If the person's income is more than 75% above the income eligibility guidelines, they're not eligible. In criminal matters, the will note that the defendant is ineligible and will submit the form to demonstrate it. Oh, that they're ineligible. They must submit it. That means they have to accept it. Remember how they don't want to accept our applications because we're calling them out. If they're not accepting our applications, how many other people are turned away? We're not accepting your application. If eligibility or ineligibility cannot be determined as described above, the scoring instrument will be completed. What's the scoring instrument? Oh yeah, that was that one. Right? Let me go back and show it to you. This is the scoring instrument. Okay? So, the scoring instrument, if you don't have enough money, you must automatically qualify. If you make more than up to 10%, and we'll go back over that number, and you have monthly expenses, or you have a class 1 or class 3 misdemeanor or jailable traffic offense, misdemeanors are jailable, 25, 100 still makes 150, right? So you would be allowed to have $1,500 in assets. 10% within $100 of the income. Now remember, okay, automatic, or there's an exception to the request. Some months you might make more. You might be a seasonal employee. You might be making $6,000 a month working construction in tall buildings. But as soon as winter hits, you only work 6 months out of the year. So then you would qualify, right? Because if you made $6,000 a month for 6 months, $3,600. If Otto made that, he'd still be under the 75%. Then we'd look at what his rent costs and other expenses. What are the expenses, by the way, kids? Rent, mortgage, groceries, utilities, clothing, child support, medical and dental, and other expenses as identified by source. What's the value of your car, right? So remember that your assets subsidize. Oh, we forgot this, right? Income from roommates gross income shall not include income from TANF payments, food stamps, subsidized housing, veterans benefits earned from a disability, child support payments, or other public assistance programs, right? So if you're on public assistance, that's not income. If you get cheap housing because you're poor, that's not income. But if you tell the judge you live in a vehicle and you can't afford to pay rent and you're not qualifying for any of that stuff, that's the information under oath that you are giving, and you're at or below guidelines. Why did Rudolph get flipped off? Because he doesn't know how to listen to Chief Justice Directive 0404 and follow his boss's instructions. So there's a instrument. There's asset categories. Your home is a rolling vehicle. His home's got whatever. It's not worth that much. You can't afford to buy a vehicle and not live in, not have a mortgage because you bought a $100,000 class, A class vehicle that's fully modified out. He's not living in a luxury RV here. And the total score will determine whether the person will be represented at the state expense or whether the person is not eligible for representation on the basis of indigency. The public defender or the defendant may request an exemption to the eligibility determination based on the score and may submit documentation for the reasons for the exception in court. So if you're not giving an oath saying I'm shit poor and I can't afford to pay for my own flipping attorney, because they think you're too wealthy and you're on the borderlines, you still have a right to ask for an exemption. And the public defender has a right to ask for that exemption as well. And then the court, which then has the opportunity to make an appointment decision based on all the information. There's wages, rates, fees for the cost of the lawyers, the type, it's all charted out. None of this is willy-nilly. All of this is designed intentionally to make sure that you are innocent before proven guilty. And you guys, while I'm scrolling through this, I'm going to talk to you. Damn it. Because here's what it is. Here's what this is like. In the city of Denver, the district attorney's office is funded by $25 million or something crazy. And the police department is 40% of the city's budget. But the public defender's office is only funded with $2 million. And this year, 2019. The courts, no, not the courts. City Councilwoman Candy Cidabacca has publicized the process, of the budget for the city of Denver. And she noticed the city attorney's office, their request for money has gone up 25%. The public defender asked for no increases. And they may not have asked for an increase for years. Thank you, everybody. So why? Why are people being denied the public defender? If 40% of over $1 billion is being spent on policing the city, and you and I all know that people take plea deals all the time because they can't afford a public defender because the process takes too much time, because there's too much fucking energy required to prove that I'm not guilty and I just want to get on with my life. Eric Brandt keeps talking about how people have to... He's not usual. He doesn't have the same mental state to say, oh, they slapped me on the wrist, I might not do that again, right? Did you ever stick your finger in hot water to test it, see if it was hot before it bubbled? Right? Eventually you learned, oh, I can see it's bubbling, I know it's boiling. Maybe you tried it once or twice because it wasn't so hot and it didn't burn you, and eventually you got burned. Well, most people aren't going to repeatedly go to jail, get arrested, face down the state, the government, to say that their rights, the Constitution, the United States of America is so important to them. And here's what Otto did. He flipped off a judge. And he said, it's free speech. And it made me feel good. I'm sorry. I'm sorry that I did that. He said he was sorry. I was standing right there. I listened to it. It made him feel good. You should feel good to be an American. You should be proud of the Constitution. You should be proud to stand up and say that shit is fucked up and stuff. And I'm dying. Have a good day.